Okay, so welcome to today's session on Schrems II case. My name is Martin Sloan. I'm one of the partners at Brody's, and I'll be presenting today alongside Grant Campbell. I suppose there's two parts to today's session. So we'll start off with Grant, who will take you through the background to international transfers under EU data protection law and the history of the Schrems case. And then he'll take you through the decision and what the court has said and look at the initial responses that we had from regulators. Grant will then hand over to me, and then I'll talk a bit about what trends we're seeing since the decision in July in terms of how organisations are dealing with this, with their international transfers, and maybe a plan for how you can tackle the transfers you make, and also look ahead to the impact of the Schrems II decision on EU-UK transfers following the end of the post-Brexit transition period at the end of this year. So I think we're now just ready to go, so I'll hand over to Grant.
Thank you, Martin. Afternoon, everyone. So I want to talk a little bit about the background in terms of EU law before turning to the actual Schrems decision itself. So I appreciate that many of you on this session are data protection practitioners, so I'll keep this quite high level, but it's useful, I think, just to get into the scene for the Schrems decision. So you'll be aware that transfers of personal data outside the EU are only permitted in certain circumstances, generally when there is a justification in terms of Chapter 5 of GDPR, so that's Articles 44 to 50. And remembering that for EU law, transfers also includes remote or viewer access to data within the EU from outside. So looking at Articles 44 to 50, there are a number of options. So if you are transferring data to a country for which there is an adequacy finding, then that's straightforward. There are currently 12 decisions, although unfortunately, most of the mainstream jurisdictions where you're likely to be transferring data are not covered by an adequacy decision, which moves you into looking at some of the other alternatives. So in terms of appropriate safeguards, binding corporate rules under Article 47, these need supervisory authority approval. Standard contractual clauses, which I'm going to turn to because that was the focus of the Schrems decision. Approved codes of conduct, we're seeing some movement now in the market on those. The initiatives like EU Cloud, etc., coming from industry, but not something that's used terribly often. Also approved certification mechanisms, but binding corporate rules and standard contractual clauses are the main safeguard we'll know about. Also worth mentioning, I think, particularly given where Schrems II leaves us, that Article 49 contains derogations for specific situations. So explicit informed consent, although that is actually really quite onerous, so not many people use it, where it's necessary for the performance of a contract with the data subject or entering into steps preparatory to entering into that contract. The problem there is GDPR recital 111 suggests that transfers need to be occasional, i.e. not systematic. So again, quite restrictive. And then finally, for kind of ad hoc transfers, so where they're not repetitive, there's a limited number of data subjects and necessary for a compelling legitimate interest, then you can use a derogation, but you have to notify the supervisory authority. So Article 49 is there, you shouldn't lose sight of it, but for large-scale systematic transfers, probably not that useful. So next slide, please. So I mentioned standard contractual clauses. These are clauses that were approved by the European Commission for the purposes of legitimating transfers of personal data outside the EEA. There are two versions for controller-to-controller transfers. One has a joint and several liability model, the other doesn't. And there's also one version for controllers to processors. And they create contractual commitments between the data exporter and the data importer. And probably this has been the most common mechanism that's been used to paper international transfers where there is no adequacy decision. Partly because they allow for systematic transfers of data, they don't require supervisory authority approval, and because of the ease of use, you can't negotiate their terms. So actually, in many ways, I think a lot of organizations have used them simply to paper transfers. That is the kind of background, I think, to the Schrems decision, which I'll turn to now. So what was Schrems about? So Schrems was challenging Facebook's transfer of his personal data to the US, and his concern was the US law enforcement surveillance powers, and all of this, I guess, was highlighted by the Snowden revelations, which revealed effectively industrial scale surveillance operations being carried out by the US intelligence agencies. So that was the basis of the concern. I suppose the timeline to this goes way back to 2000. It was clear that the US, because of the legal system that it has, and the fact it has no federal data protection laws, it was always going to be difficult for the European Commission to make an adequacy finding for the US as a country. So in 2000, it adopted a safe harbor adequacy decision. For those of you who are in data protection long enough, you'll remember this. This was effectively a self-regulatory scheme under the auspices of the Federal Trade Commission, and it was in place for about 15 years until Schrems, Max Schrems, who's involved in the Schrems II decision, got involved, and as a result of that, European Court of Justice declared the safe harbour scheme to be invalid. So that was in 2015. And basically the basis on which the decision was reached was similar to the issues in play in Schrems II. So what Schrems was saying is safe harbour doesn't adequately protect our data in the US because it doesn't bind the intelligence agencies, and there are lack of effective judicial remedies if the terms of safe harbour are breached. So safe harbour was declared invalid in 2015. In 2016, Schrems commenced a challenge over Facebook's use of standard contractual clauses. And at the same time, but at the time unconnected, the European Commission and US government agreed Privacy Shield, which was the successor to Safe Harbour, which was a kind of Safe Harbour on steroids beefed up. And the Commission thought that that actually met the concerns that had been voiced about Safe Harbour in Schrems I. So on the basis of the challenge to Facebook's use of standard contractual clauses, the Irish courts, because Facebook in the EU is based in Ireland, referred a number of questions to the European Court of Justice, including questions about Privacy Shield. And probably this is slightly the law of unintended consequences, because Schrems' original challenge was to the use of standard contractual clauses. Facebook brought in the issue of Privacy Shield in terms of saying, look, the US actually is not such a difficult jurisdiction because, look, the European Commission have blessed this Privacy Shield arrangement. So that brought Privacy Shield within the arguments that the European Court were being asked to look at in terms of the validity of standard contractual clauses. So Schrems II considered the lawfulness of both standard contractual clauses and Privacy Shield. Next slide, please. So the court, as part of Schrems II, looked at two US laws dealing with surveillance. The first is Section 702 of the Foreign Intelligence Surveillance Act, FISA, and that allows the US Attorney General or the Director of National Intelligence to conduct surveillance operations on non-US citizens and to compel electronic communication service providers to assist them to do that. And then there's Executive Order 12333, which is actually an instrument that was signed by Ronald Reagan way back in the early 80s. But that kind of sets the framework against which organizations like the CIA operate and compels other parts of government to cooperate in their investigations. So these were the kind of two areas of US law that the European Court of Justice was being asked to look at when considering whether or not the safeguards and Privacy Shield were going to be sufficient to provide adequate protection to the rights guaranteed to EU citizens under the Charter of Fundamental Rights. So where did the European Court of Justice go? Well, the European Court of Justice dealt with Privacy Shield first, and it basically said the Privacy Shield doesn't work. The decision is invalid. And basically it said that the surveillance rights under US law cut across GDPR and also the EU Charter, and the safeguard, the effective remedy through the Privacy Shield Ombudsman didn't work because the Ombudsman itself was toothless. It didn't have sufficient powers, and the national intelligence services in the US were not bound by its decisions at all. So Privacy Shield was struck down. The court then turned to standard contractual clauses, and this is, I guess, more nuanced. So what the court said is, in theory, the decision of the standard contractual clauses are valid, but the contractual guarantees in the contract are only part of the story. They alone are insufficient. So if you are exporting data to a country which has a regime that might override the protections that are set out in the standard contractual clauses, then you will need to consider whether or not you can put in place supplementary measures to protect that data to ensure effective equivalence to the rights that are guaranteed under EU law. And if that is not possible, then you shouldn't be using standard contractual clauses to justify transferring personal data to that country. And what is clear from the European Court of Justice decision is that it has clearly put the onus on the parties to the contract to make that determination. So the data exporter has a decision to make as to whether it is satisfied that the contractual clauses, as supplemented by any supplementary measures felt necessary, adequately protect the data when it goes to the importer. So specific issues that the court drew out were in terms of proportionality. There were no effective limitations on the rights of US law enforcement to collect and use data for surveillance purposes. Bulk surveillance meant that what they were doing wasn't limited to what was strictly necessary, and there was a lack of adequate judicial redress for individuals under US law. So the European Court of Justice was fairly damning in terms of the US legal regime and whether it would respect the fundamental rights of European citizens if their data was transferred to the US. Next slide, please. So where did that leave us? Well, in terms of regulatory response, the European Data Protection Board was fairly quick to come out with a reaction. First thing it said is there is no grace period for compliance. So if you are using Privacy Shield to justify transfers of data to the US, you need to stop. It is invalid. You cannot use them. And that was effective immediately from the decision being made. European Data Protection Board also said that the impact of Schrems is likely to affect all Article 46 transfers, and that includes binding corporate rules. So whilst the decision was focused around standard contractual clauses, those who are using binding corporate rules weren't immune and would have to think about that too. What they promised is that they will provide guidance on possible supplementary measures, but to date, nothing further has come out except that the European Data Protection Board is establishing a task force to look into 101 complaints that have been filed with European supervisory authorities in connection to companies that are using Google and Facebook services. And these complaints have come from Max Schrems' privacy group, None of Your Business, which has filed all these complaints on the back of the Schrems decision. European Commission and US government, well, US government's immediate reaction was nothing's changed. As far as we're concerned, Privacy Shield has not changed. So I think though that completely ignores reality. No one will be using Privacy Shield from the European end, given the court has struck it down. So clearly there are ongoing discussions now and urgent discussions now between European Commission and US government to actually see what can be done either to replace or improve Privacy Shield. Fundamentally though, I think in order to get around the issues that the court has highlighted, there are going to need to be some major changes to US law, and whether or not there's a political will in the US to do that is the big question. More immediately in Ireland, the Data Protection Commissioner has issued a preliminary order to Facebook to stop EU to US data transfers using standard contractual clauses, because given the observations that the European Court made in terms of Privacy Shield when striking it down about the US legal system, it's pretty clear that you can't paper transfers to the US using standard contractual clauses without having at least some additional safeguards in place. And ultimately, I think the challenge here is a political one. Schrems, both Schrems I and Schrems II, are fundamentally about the power of law enforcement agencies to collect data for intelligence gathering purposes. And unless and until some way of reconciling their powers with the privacy rights of individuals under EU law is made, there'll always be tensions between any mechanism to legitimize transfers to the US and the powers of these organizations. So standard contractual clauses and binding corporate rules are between private parties unless there is some mechanism to bind intelligence agencies into respecting those things. It is always going to be difficult. So what I'm going to do now is hand over to Martin, who's going to explain, give some thoughts as to what we can do. So Martin, over to you.
Thanks, Grant. Yeah, so what I'm going to do over the next few slides is look at what we've seen emerge in terms of trends and practice since July. And this is based on the contracts that we've been advising on and data transfers that are ongoing at the moment. And a lot of this reflects what we're seeing in terms of wider industry trends. And I'll also have a look at what this means for transfers between the EU and the UK following the end of the post-Brexit transition period. So we can go to the next slide. So as Grant says, that this is all about trying to work out how you can include, well, firstly understand whether the standard contractual clauses are undermined, and secondly, how you can mitigate that through supplementary measures. So there are, I think, several questions that you'll want to ask. So the first one, do any local laws undermine the standard contractual clauses in the destination territory for your transfer? That's first place to start. Secondly, having established whether or not there are any local laws that are potentially an issue, is your data importer or someone in their supply chain subject to those laws? If they're not, then you may be fine. Is the transfer necessary? Can you use technical measures? And I'll look a bit more about what that means to protect the data. And if that's not possible, can you use other supplementary contractual mechanisms to deal with this? What might they look like? And then having considered all of that, the question is then, what is the overall risk? And is this a transfer that you think can be made, or is it such that actually there is still a substantial risk to data and therefore the transfer cannot be made? So we can move to the next slide. So here's my action plan in terms of how you might want to look at your current international transfers or ones that you have coming up. So step one, audit all your current data flows. And I know we all did this in the run-up to GDPR, but I think it's a good time to look again at your contracts and where there are international data flows. You may find that some of your contracts are a little ambiguous as to whether or not a transfer is actually taking place. So first step, identify what transfers are out there or may be taking place. And then the next step is the diligence one. So you need to understand, having identified where those transfers are taking place and what countries are involved, what the powers of law enforcement are in that destination territory. And you're going to need some input from your supplier or whoever it is that you're transferring to understand that. You may also need local law advice on the regime there as well. Understand whether your importers subject to those powers and rights. Again, you need them to tell you what they are doing, how their business operates. But also find out whether they've received requests in the past. So if someone is potentially within scope, you may take comfort in the fact that yes, they are potentially, but actually they've never had any requests. And we know, you see organizations like Google and others who will publish transparency reports on the requests they actually receive, and they are very open about that. And then look at what personal data is being transferred as well. What is that data? How sensitive is it? Who are the data subjects? Are these things which means that it may be more susceptible to surveillance by law enforcement compared to other types of data? And you may decide that certain arrangements are less at risk than other ones. How do you do this? Well, what we've done is we put together some standard questionnaires that can be used for transfers to the US and also for transfers in other parts of the world, which you can send to your data importer and ask them questions and all of this, and then use those answers to assess as part of your assessment of the risk. You can also potentially use whitelists. So if you've done diligence on a particular country or territory or a particular type of supply in that area, you might consider, right, we've done our work in this. We know that for this type of service organization in this country, that's fine. And if you can record that information and use whitelists, then that might be a way of cutting down some of the repetition in terms of the diligence you need to do. So the next step then is looking at technical measures. So if you identify that the destination territory is one where there are laws which may potentially cause an issue, then you want to look at your technical steps. So is that transfer actually necessary? Could the processing take place within the EA or another country where there's an adequacy decision has been made? Or does it have to transfer to that country in order for that processing to be carried out? And then you want to look at things like encryption as well. So is the data encrypted? Is it encrypted at rest? Is it also encrypted when it's in transit? And is that encryption sufficiently strong enough? Because if that data is properly encrypted and the NSA, whoever it is, can't get access to the keys to decrypt it, then it's probably pretty secure unless they're able to hack that. So you need to understand the technical measures that are being used. But it might be, as I say, that you can use those to mitigate the risk of surveillance or interference with the data. Okay, move on to the next slide, thanks. And then contractual protections. So I think the starting point here is to remember that the standard contractual clauses already contain clauses in them, but I think we perhaps have forgotten about those because we tend to view the standard contractual clauses as being standard documents, but actually there are clauses in there which require the importer to tell you about changes in law that might impact on the protection of the data in that country, or if they receive a request from law enforcement. So there's some good stuff in there already, but clearly in the Schrems II case, the ECJ didn't think that was sufficient. So think about what else you can do in your contracts. So that might be additional rights to suspend or terminate transfers, for example, where you just think the risk profile has changed, or where there's a change in guidance or whatever. Look at building in additional rights to your contract. And perhaps more importantly is disclosure obligations on the data importer. So beefing up what's in the standard contractual clauses, requiring your importer to be more to provide more information on issues or factors that might impact on the protection of that data. As I say, a number of large IT companies use transparency reports, and they're really useful for understanding the risk. So that would tell you not just about requests for your own data, but actually the requests that organization receives for any data that it holds, a really useful tool. And I say then think about mechanisms for dealing with changes in law or regulatory guidance as the supervisory authorities develop their own position on all of this. And then having gone through all of that, you then have a risk assessment to carry out. So it might be that you identify there's an Article 49 derogation that's available. Grant talked about those before, though for many transfers, they're going to be of limited use given the specific nature of them, but they're certainly worth considering. Look at what data is being processed, who the data subjects are, how the laws apply to that data importer, and then assess all that against the technical measures that you've identified or that you can put in place and the other supplementary measures you can put in the contract. And once you've done all that, you can decide whether or not you're comfortable to proceed with the transfer. And what's really important with all of this, and with any, we say this all the time in relation to data protection law, but document your approach. Be able to demonstrate why you've taken the approach that you've taken, the diligence you've done, and all the other stuff. And if you have actually reached that decision, you're making the transfer, then if you can show you're working on that, if it's challenged, then you're going to be in a far better position. Okay, so just want to talk a little bit about transfers between the UK and the EU. And for those of you who've joined our previous webinars, you'll know we've spoken about what happens to data protection law at the end of the post-Brexit transition period. But there are particular issues arising out of the Schrems case, which you'll need to bear in mind if you're an organisation that shares data with other parts of the EU. So at the end of transition, the UK becomes a third country. And while the UK has said it's going to adopt all the current adequacy decisions that the Commission has made in relation to third countries and standard contractual clauses, and it will also consider the EU to have an adequate level of data protection law for transfers from the UK to the EU, that doesn't deal with transfers coming back the way. So it is for EU law to decide whether or not the UK has an adequate level of data protection law. And as we stand at the end of September, we still don't know whether or not an adequacy decision will be in place for the end of the year. And it's important to remember that, that the process for making adequacy finding is is very structured within the EU, so there's a process to follow. It's not something that is bartered as part of a trade deal. It's not automatic, and there are some very genuine questions in relation to the compatibility of UK surveillance laws with EU law, and the UK government has been in court a number of times in relation to challenges to its data retention laws, and these are the sorts of things which the Commission is going to need to consider when it's carrying out its adequacy assessment, and that I think is brought into even sharper focus following the concerns raised by the ECJ in the Schrems II decision. So we're in a position with a couple of months to go where we don't know whether there will be an adequacy decision, which means that if you are receiving data from the EU, then you're going to need to start preparing for no adequacy agreement being made. So say this is only relevant to transfers from the EU, but if, for example, you have a group company in another part of the EU that transfers data to you, or you are providing services as a processor to someone in the EU, then all of this will be relevant. So what can you do? Well, we mentioned Article 49 derogations. They're unlikely to be relevant in many situations, but they may be worth looking at. Binding corporate rules, yes, they would work for intergroup transfers, but there's no time left to get those approved because the approval process takes quite a long time with the supervisory authorities. So for most transfers, that leaves you with standard contractual clauses, and then needing to look at all the stuff we've spoken about today in relation to Schrems II and supplementary measures. So that means that you'll probably find if you are a data importer to the UK that you will start getting questions from the EU exporter on UK surveillance laws to help them understand all the things that we've been looking at. So in terms of actions, look at your EU UK data flows, understand where they are and what data is being transferred. You'll need to work with the EU exporting entities to help them understand UK law and the potential risk, and that's not just what are UK data retention laws, but how do they apply to you as an organisation? You need to understand that position. Look at technical measures we talked about. Look at what you can include in your contract, and then you want to keep all of this under review and look at what you can put in place. So that might be putting in place standard contractual clauses on some form of temporary suspensive basis, but together with all the other supplementary measures. And as I say, it's really important with all of this that you clearly document your approach and you have all this ready to go, so that if there is no adequacy finding by the end of the year, then you are able to keep on carrying on with those transfers. So that's all that I wanted to say. I'll pass back to Grant for the Q&A.
We have a number of questions actually. So the first one is, if your organization is using platforms like MailChimp, Doodle, Eventbrite, where the data is processed in the US, do you need to start thinking about an alternative provider?
Shall I?
Do you want to pick that one up?
Yeah, so I think it may be you can still use them, but I think you need to go through some of the diligence questions that we talked about before. So, I know that some of these platforms have historically been very reluctant to host data in the EU, but I think we will see a change over the coming months from a lot of operators, and certainly I noticed that pretty much overnight with the Schrems decision. There was in mid-negotiation on a contract where the vendor had been very rigid in its approach, shall we say, and then actually on a lot of this stuff in terms of giving additional commitments, they totally changed their approach because they realise actually that the way they have operated up until now is not going to work going forward. So I don't know with MailChimp or Doodle what their current approach is, but it may be that they are actually looking to host data in the UK or the EU rather, and can ring fence that in some way. So I'd certainly do your diligence first before deciding the nuclear option.
I suppose that leads on to a second question, which is really around the due diligence side of it. So, do we think that there are going to be service providers that are going to start providing reports to, questions around, people like anti-bribery and corruption service providers who, provide us a report for a territory, that others can rely on? And I suppose in my mind, it was a bit like the Sarbanes-Oxley reports where, you may have organizations who commission, big four companies, etc., to provide reports on particular organizations to take some of the due diligence burden away from data exporters. I certainly think, I haven't come across them yet, but I certainly think that is an obvious thing for data importers to do. So the big service providers in the US, to get reports from some trusted third party then that can be used by those who want to use their services to say, here are additional safeguards, here is an analysis of the jurisdiction and how we are caught or not caught by these investigatory powers. And that on the back of that, we considered that actually the use of standard contractual clauses backed up by that report was adequate. There are quite a few questions now. So in terms of, I think the question here about whether we think the EU is going to think the UK is trustworthy, and I mentioned that the Snoopers Charter means that the EU won't consider the UK as having adequate protection. I think, you know, the question as to whether or not the EU considers there should be an adequacy decision, I think, is in the balance. I think there have been serious concerns raised about the UK's Investigatory Powers Act and the powers that have been given to the intelligence services. So I think, you know, there is a risk, a real risk, that the EU won't feel able to give an adequacy decision to the UK.
I think just one point to add on that is that, and it was flagged yesterday by there was a white paper published by the US government in relation to where we might go with some of this, and one of the things that it notes is there's a degree of hypocrisy here, and actually if you look at the US powers, law enforcement powers, and then you look at a lot of EU member states, actually a number of them have very similar powers for their own law enforcement agencies, but just because they're already within the club, within the EU, those aren't assessed in the same way that you have inadequacy finding for a non-EU country. So yeah, it's not necessarily the EU is doing, so UK is doing something that entities in the EU are doing, but more just the adequacy procedure means that it's subject to much more scrutiny.
Okay, we've got more questions, but I'm afraid that we are out of time. So if you have given us your name when you've submitted a question and we haven't actually answered it, then we will try and get back to you directly offline. But we have sadly run out of time. So thank you all for coming and joining us. You have our contact details on screen. If you want to contact us offline after this, then please do. Otherwise, thank you very much and enjoy the rest of your day. Thank you.